Welcome to this final session of the Constitution Unit's summer conference on the future of the Constitution. No, that's the wrong script. I'm Meg Russell and I'm the Director of the Constitution Unit, and I'm here to chair this final session with our very illustrious guests. As people who've been at earlier sessions of the conference will know, we've been trying to be very future-focused at this conference, looking across the broad gamut of the Constitution. We've had sessions on Parliament, devolution and the Union, the courts and the rule of law, elections and electoral reform, and constitutional standards. And our focus very much is not the past and what may have gone wrong, but looking ahead to the future with a general election on the horizon, almost certainly in 2024, and thinking about what parties might be putting in their manifestos and what the next government might be going to do, which doesn't mean that we can't talk about what the current government could do very quickly, and it doesn't necessarily mean, of course, that the next government is going to be a different kind of government to the current government, because a year is certainly a long time in politics. We've heard a lot of ideas on our earlier panels about things that can be done quickly, things that can be done with more effort through legislation and so on, and a very wide range of stuff. But the question is, how do you actually get this done? And how does it all fit together? We're all perhaps to some extent constitutional obsessives by virtue of being here, but the country and any government will be very much focused on other public concerns, the state of the economy, foreign affairs, the state of the NHS, etc., etc. And these issues, although people consider them important, are perhaps relatively low salience compared to some of those. So how do we get constitutional reform prioritised and put into practice? How should parties approach this before the election, and how should it be approached when in government? We've got two fantastically well-qualified people here with very significant experience close to and in the centre of government. I will introduce them briefly. We have Sir David Lidington, who was the Conservative MP for Aylesbury for 27 years, from 1992 to 2019. He was a Foreign Office Minister in the coalition government. He then served under Theresa May as Leader of the House of Commons, Lord Chancellor, and finally within the Cabinet, from the Cabinet Office as effectively Deputy Prime Minister. Former claims to fame include, I think, leading the winning team on University
Indeed.
Challenge a few more years ago, and being a special advisor to Douglas Hurd in the 1980s. He's now on the board of the Institute for Government, and he chairs the Royal United Services Institute, among other things. And he had a terrific article in the Political Quarterly recently, if anybody hasn't seen it, on a Conservative case for constitutional reform. And then we have Charlie Falconer, Lord Falconer of Thoroton, who's been a member of the House of Lords for Labour since 1997. He served as a minister in the Home Office and the Department for Transport, Local Government and the Regions. He was Secretary of State for Constitutional Affairs and the first Lord Chancellor after the Constitutional Reform Act 2005, serving until 2010. Charlie's still a practicing barrister, and on appointment to the Lords, famously got into the papers quite often as Tony Blair's former flatmate when you were young lawyers together, and seen as a confidant of Blair from way back when. And of course, Tony Blair was a Prime Minister who arrived in government with a big and ambitious constitutional reform programme, much of which went on to happen. So we're going to have a bit of a chat, and then we're going to throw it out to the audience for questions. Those tuning in on Zoom will be able to see that this is a rather different event to all of the others in the conference, in that we do have an in-person audience here, a relatively small but actually pleasingly large invited audience of people here in the room. So in terms of questions, I am going to turn to the room first, and there is a Q&A function in Zoom which people are invited to use, but I'm not sure whether we'll get to the Zoom audience because we actually have quite a lot of people here in the room. Like all the panels at this conference, this is being recorded and it will be made available as a video after the event on our YouTube channel, and it will also be an edition of our podcast So when you're asking questions, do bear that in mind, that you are being recorded. So that is plenty from me. So we haven't really had much of a chance to choreograph this, but David and Charlie, you both have a passionate interest in constitutional reform, and you've both been there right at the centre. Could you maybe just very briefly give us a flavour of what it's like at the centre of government and where constitutional issues sort of sit in the hierarchy, and just how frantic it is and how things get notice, and you know where this is likely to be in the priority list for a new government. And we have no choreography. Charlie's ready to go?
Yes. First, my experience of being at the centre of government in relation to constitutional reform is that one's political colleagues have next to no enthusiasm for constitutional reform. That is putting it benignly. Many of one's colleagues have a positive opposition to constitutional reform. 3 particular reforms that we did, which were particularly resisted internally, were freedom of information, which many of my governmental colleagues thought was mad, and my good friend Tony Blair said was the worst mistake he had made. Even after we'd been in government for about 10 minutes, was regarded as a bad idea. Secondly, Lord's reform was regarded as a bad idea for 2 separate reasons. First, the Commons are constantly anxious that this will somehow affect their primacy, and they're constantly worried this may affect the Prime Minister's ability to bestow patronage. And then thirdly, human rights was consistently resisted on the basis it gave judges too much power when the politicians want to keep power. So point number 1, one's political colleagues are normally against it. Point number 2, it does happen if there is either a very big parliamentary majority or there is a very profound sense that some part of the Constitution is not working, and the ability of the politicians to say no to it is thereby compromised.
David, you were in your last period in government was an unusually troubled one during the Brexit years, and I think that aside from one big constitutional reform, there probably wasn't much focus on anything else. But you were also there in less central positions during the Cameron-Clegg years, of course, when there were big ambitions. How would you say?
I agree with everything Charlie has just described, but I would add this, that when you're at the centre of government, and I think this is true, the more senior post you hold within the government, the greater the pressures are on the diary, and the pressures of events. And every Prime Minister, every Senior Secretary of State has people clamouring for 15 minutes of their time. There is always a backlog of decisions, each of which, on its merits, should be regarded as both urgent and important. And in those circumstances, I think what is true is that, on the whole, constitutional affairs, as Charlie said, tend to come to the fore and grab attention when there is a crisis, when something is visibly not working. So in my case, in one example was the Scottish and Welsh governments, who were kicking up a very big fuss, and I heard from them both, and I checked the record, and it was true that the committee that was meant to consult them and coordinate approach to how one implemented the referendum result had not met for a year. Now, that was clearly indefensible, and we did something about that. But that was just an example of things coming to the fore because there was a crisis. Otherwise, it's easily pushed to one side for everything else. On top of that, most, but not all, constitutional reforms need legislation. And there are always far more bids by Secretaries of State for legislation than there is legislative time available in any one parliamentary session. When I was Leader of the House, one of the jobs of the Leader of the House is to chair this body called PBL, the Public Business and Legislation Committee, that usually meets in this subterranean sort of lower ministerial conference room in the Palace of Westminster. And your job as leader of the House in particular is to beat up your cabinet colleagues and tell them that they can't have the bill that they've dreamed of, or that you're going to excise great chunks from it, just to ensure that it is manageable, and particularly if you have a small majority or no majority, that you can assemble a majority to carry it through the Commons, and then you've got to take account of the House of Lords, where nobody has a majority, and the guillotine procedure is not available to you. So legislation is even if you've got attention on the issue, getting a legislative slot, if you need legislation, is difficult. But my final point would be this. Sometimes a significant constitutional change can be effected without legislation and without a crisis in government. And the example I give is at the very end of the Labour Party's term in office, Tony Wright, then a Labour MP, produced a report on select committees and reforms to the select committee system that garnered all party support across the backbenches, both Conservative and Labour, and the pressure on the respective front benches from their backbenches was such that they felt they had no option but to implement most of what Tony had proposed, which is why you have select committee chairs elected by the House as a whole rather than being creatures of Whip's office patronage, and that has indubitably strengthened the authority of select committees in terms of public debate.
And clearly, I don't want to rerun entirely a very good seminar, which is still available, the recording online, that we did with Charlie a year or so ago on the 25th anniversary of the 97 election, I think, where we talked a lot about the programme in 97. But it is interesting to think a little bit briefly about the parallels, because notwithstanding what you say about how difficult it was, that was a huge programme. An awful lot happened very quickly. And so I think, to just come back to you a bit, how did it happen? And maybe if we think our way through the process starting with the pre-election period, how ready do parties need to be in order to enter and successfully implement reform? And what would your advice be, perhaps to Labour now, in terms of readiness to implement change?
I mean, having been rather damning about political enthusiasm for constitutional reform, there is from time to time a tide in the affairs of man where the moment appears incredibly ripe. And the moment in 1997, or in the build-up to 1997, appeared incredibly ripe for constitutional reform. And the reason for that was the sense within the country, and I say that rather wildly, but I do think there was a sense that the Conservative government had completely run out of steam over a very long period of time, primarily in Scotland, and to a lesser degree in Wales, to a very considerably less degree in Wales. There was a sense that the constitutional position of Scotland had to change because of the constitutional opposition to there being no devolution of any sort, and the opposition to the Conservative government within Scotland. And in relation to the way that the Labour Party was presenting itself at that particular time, we were a modernising government, and in particular aimed to modernise the constitution as a whole. So there was a moment in time where big constitutional change was specifically put on the table, and it reflected a sense of the way the country might change if the Labour Party won. It would never have happened if there had not been massive amounts of preparation prior to 1997, because any attempt to effect very major constitutional change, unless it is properly prepared, goes completely awry. And we were ready on devolution, we were ready on human rights, and we thought we were ready on freedom of information, but I don't know if you remember, we produced a white paper, which by this time, as it were, the forces of darkness had rather risen to the fore, and that was ditched. We were ready to get rid of the hereditary peers in the Lords. We weren't ready with any detailed proposal for electoral reform in the Lords. We were ready, to some extent, for steps to electoral reform, but unfortunately the political will melted away in my party the moment we had a majority of 150. Why would you ever want to share power? Why would you ever think you were going to need to share power? So preparation, and is there a tide that is in favour of it? And I mean, at the moment...
Do feel free, of course, in these remarks to talk about how organisations like the Constitution Unit helped in having the detailed plans, because it's not just the Constitution Unit these days. We've got people here from the Institute for Government who, of course, produce, and David is involved in that, who produce reports full of detailed proposals, and I think that was useful.
It was incredibly useful, and you're absolutely right, the Constitution Unit was incredibly important in preparing for, helping us prepare both in detailed conversations with Labour and opposition and in the reports that were written, and in, beyond that, as it were, making people address the detail of those issues both within the Labour Party, which then became the Labour government, but more broadly, so that when the time came, it looked possible to do it. I mean, there's a huge amount of discussion at the moment about electoral reform, because there is a sense the system is not working in a whole variety of ways. There's absolutely no real thought gone in anywhere as to what that might look like and how you would build a consensus in relation to it. And it feels incredibly dependent upon what the result of the election will be.
And of course that happened later, because that came through the Jenkins Commission,
Yeah,
didn't it?
yeah.
Which was one, when we come to sort of how you plan things, starting commissions, starting reviews is something that you can get going very early to...
You might want to start a commission or review, or you might want to go straight for a particular reform. I mean, my own view at the moment is that there will be probably no appetite except for changes that address, as it were, the sense of stink about our elected constitution at the moment. So, for example, we should be thinking about how you ensure compliance with things like the ACABA arrangements. We should, for example, be thinking about how you get rid of the hereditary peers, the remaining ones, probably by stopping the by-elections and thereafter letting them die out. We should be thinking about how you reduce the size of the House of Lords. We should be thinking about how you ensure proper standards of propriety within the Commons. But these are important, but they're not massive. But they could be done by legislation that could pass without there being a massive taking up of legislative time, which David was saying would be a problem.
And David, having been in the centre in government, what are the appropriate mechanisms? Mechanism makes it sound very much like it's to do with sort of specific organisations. One thing I was going to say to you is I read somewhere that you chaired, I think, an unprecedented number of cabinet committees when you were in government.
Like it, yeah.
So cabinet committees are one way of doing this,
Yeah.
obviously, sort of organisationally. But in terms of tying everything together, can you just talk to us about how to think through what goes in the first year, what goes in the second year, how you get things in the legislative programme, or what you do non-legislatively?
When you're appointed as a minister after a general election, then your senior officials come to you and they have a folder, and they will have prepared a colour-coded folder for a minister of all the parties that the civil service thinks might get into government. I think that in 2010 they very hurriedly prepared some orange folders to have available. But normally there'll be a red folder and a blue folder, and the folder appropriate to you will have a list of those things pertaining to your ministerial responsibilities that were in your party's manifesto, or your boss, the Secretary of State, or you if you are the Secretary of State, or the leader of your party, the new Prime Minister, or the new Chancellor has committed themselves to. And so they will be saying, look, this is what you want to do. Now, we suggest that these might, you want to understand your priorities. This is our first guess at those. Are we right about that? Then you will, as the minister, be presented over a number of weeks with a series of decisions about this. But the first Queen's speech will have been worked out in opposition. You know, whether it's Rishi Sunak or Keir Starmer, who is waving from the steps of number 10 in November next year, there will have been a meeting of the leader and key advisors and trusted cabinet ministers or shadow cabinet ministers to decide what will be in the first Queen's speech, which bills have priority, and those will have been rubber stamped by the cabinet or shadow cabinet as a whole. So that will all be spoken for, and the officials will know that because if it's the opposition that comes into government, they will have had conversations with the permanent secretaries of each of the Whitehall departments. So the top officials in each department will know what the priorities of the Labour Party will be, or a re-elected Sunak government would be next time. And so you're anything beyond that, you're looking at year 2 or later. So what you do as a minister is to work up the policy. You, through a series of right rounds and cabinet committee meetings, you seek collective agreement for the policy content of what you want to do, and then for each stage of drafting a bill, for a bill's content, then you have to go to the business managers, the leader of the House, the chief whips of both houses, and ultimately PBL committee, and say, look, this is my bid. Assuming it's the Secretary of State backs it, this is my bid for this year, and then it'll be considered along with all the others, and the business managers will take a steer from Prime Minister as to what he or she wishes to see as a priority. They will take a view from if the Chancellor says we can't afford it, scrap it, it probably will be scrapped. There will be there'll be a reading of the backbench mood within the governing party. There'll be a reading by the Lords business managers of the mood in the House of Lords, the degree of opposition, and the decisions will be taken about the priority for bills accordingly.
One of the things that concerns me about that is you're talking very much about you, the minister, people bring things to you.
Yeah.
There is no minister for constitutional reform. Of course, some of this lies in the MOJ, some of it lies in the Cabinet Office, some of it's currently in levelling up. You've got stuff that the leader of the House of Commons might want to do. I don't know where House of Lords reform necessarily sits. It sat with the Lord Chancellor in the Lords, of course, back in 1997. So as a sort of doyen of cabinet committees, David, how would you coordinate a constitutional reform program? Should that be a committee? Should it be a minister?
Ideally, first of all, I would, if I were a prime minister who wanted to implement a programme of constitutional reform, I would first of all ensure there was clarity over this. And I think there's 2 ways in which you can do this. You can give it to the Minister for the Cabinet Office, who in my view ought to be always the Deputy Prime Minister with that title, because they're in effect looking after the corporate HQ of government and the implementing machinery, coordinating machinery of government. And you probably have a Minister of State there who has particular responsibility for constitutional affairs as well. Or you could locate it with the Lord Chancellor's office, particularly if you decided to reverse some of the reforms of the Blair government and you put the, say, prisons, probation back with the Home Office, or and you then had a Lord Chancellor's office that was much more focused on the judiciary, and you could say constitutional affairs as well. So there'd be 2 ways in which you could do that. You could even have a completely new department for constitutional affairs with its own Secretary of State and a coordinating role with the devolved administrations and parliaments, and with what I would hope to see with the English regional or sub-regional devolution as well. So there are different ways of doing it, but clarity, accountability, clear set of responsibilities, and you would move on from that point. But I would also, I do think things like commissions have a part to play. I think that in this country we've been slow to take up the citizens' jury ideas. There's always nervousness amongst MPs about this, but you look at how Ireland has done, and it does seem to have worked there. And actually, that sort of process enables you to tease out some of the potential problems and actually get a gauge of where the difficulties with public opinion as well as practical implementation might be.
You may want to comment on this from experience. One of the things that people have although the Labour reform programme was very successful, people have complained that even the Labour reform programme was rather disjointed. There was no sort of overall vision. So what do you think about these questions of how you tie it all together?
You do need somebody with an overall responsibility for the Constitution in government, both to indicate where the strains are and to assist in making it work. So there are so many constitutional pressures the whole time. Most obviously with the devolved administrations. Scotland gives rise to very different problems to Wales. Yep. Northern Ireland gives rise to very particular problems. When I was appointed the Secretary of State for Constitutional Affairs in 2003, I was also appointed as the Minister responsible for the devolved parliaments as well, on the basis that you did need somebody who wanted to try to make the whole constitutional settlement work. And I think one should focus on the need for a very strong constitutional minister to make the existing system work, rather than to simply be a driver of the way that you reform it. And that person has got to have political strength. What David describes about the process for fixing a Queen's speech, now a King's speech, and the committees that need to go through it is absolutely right. You're never going to get a major constitutional reform programme from that process. That process is after the decisions have been made. Yeah. And so you need, no constitutional reform will occur of any significance unless there is a big political driver for it, which probably means either the Prime Minister or somebody of enormous impact within a government.
And the Prime Minister at least has to support that Secretary of State,
exactly,
not oppose it.
And remember, what the Prime Minister is thinking the whole time is, how do I get my party re-elected? I mean, obviously, he or she is thinking of big things as well. But the job of the Prime Minister is to lead the government and to lead the party to an electoral victory. If you can imagine whoever takes over in 2024, whether it be Rishi Sunak or Keir Starmer, you're taking over in a moment of cost of living crisis, mortgages incredibly high. I propose that my first step shall be appointment of a commission to consider electoral reform. I think we've had a lot of trouble with the Lords and its insufficient legitimacy. Let's make them all elected. You saw what happened to your partners, the Lib Dems, when they tried that alternative vote referendum, and it had such political dissonance. And so there isn't, I suspect, in the context of this sense of economic failure and impropriety, which are the two sort of driving motivations at the moment, there won't be a sense that those two sorts of things, electoral reform and making the constitution more elected, will be a big driving thing. But, as I keep coming back to, there are so many things you could do which would have resonance as part of a bigger picture. Yeah. Just whilst David was talking, this idea of these officials coming to you. When I first became a cabinet minister, I don't know if you remember, it was in 2003, and we'd announced that we were going to abolish the Lord Chancellor. No officials came to me and said, here are your options. Broadly, the officials came to me and said, could we have sight of the fag packet on which this policy was written? So there are occasions. You laugh, I laugh, but ultimately you can do constitutional reform if you're absolutely driving it politically, as we were at that particular, because practically everybody was against it. We had a big majority, we absolutely drove it. And I mean, I thought for the good in a whole variety of ways, but politicians can drive reform if they're absolutely committed, but most politicians will be focusing on what are the things that most affect the electorate.
I think a lot of this is about coordination, isn't it, of different kinds. So there's the coordination when it comes to just the phasing, the planning, the what could you do in what order, but then there's also tying the reforms together. So what you're doing on the Commons fits with what you're doing in the Lords, and fits with what you're doing to the Lords fits with what's happening in devolution and so on. And those are intellectually very big tasks.
And have they ever been considered as a coherent whole? We have no written constitution. All the bits of our constitution become under strain for different reasons. So, for example, the Lords is very big under strain in public accountability or esteem at the moment because of the massive use of the patronage to appoint Lords. So the Lords are not well regarded because there are too many unsatisfactory people in the Lords by way of the appointments process. And that's where the Lords fits in. The Lords came under huge strain at the beginning of the 20th century because it rejected the people's budget or because of the risk that it was going to do something terrible in relation to Northern Ireland.
And I agree with Charlie that there is a need for a Secretary of State and a function in central government clearly responsible for constitutional affairs, because even if you made no significant new reforms, there are important bits of our constitutional arrangements that are not stable at the moment. The relationship with the devolved authorities and between them and the UK government, and how we try to make work the new intergovernmental agreement is one example of that. How we ensure that related to that, England is represented and the English interest expressed within the Whitehall arrangements and in terms of contribution to negotiations on international agreements, in the way that the Scottish and Welsh governments and Northern Ireland executive would express the views of those parts of the UK. We haven't got a comparable arrangement for England. It's uneasy. The UK ministers deal with England. And we need to sort that out. The other thing to bear in mind is that sometimes Parliament sets the ball rolling itself. And it's very much Tony Wright's reforms came after pressure from the backbenchers to get on and do something. And organisational bodies like the Procedure Committee of the House of Commons, the Constitutional Affairs Committee of the House of Lords, can play a significant role both in developing ideas, but also when it comes to House of Commons in particular, really putting pressure on the government, even sometimes backbenchers on their own government. So things, two things I really think need to be done. That it should be routine, in my view, for bills, bar the rare emergency bit of legislation, to receive scrutiny in draft form before the formal legislative process. I think it would improve their quality. And I think we need to do something to reform the programming, which I think is now being used by governments of all colours to avoid awkward and embarrassing debates. Now, what the option I rather like is to keep programming, but you give the backbench business committee the power to decide on the programming for each bill, and they proceed by consensus there. So the government backbenchers ultimately have a majority. So I think you might look at those sorts of problems. You don't need primary legislation for those.
It's interesting. That is an entirely different set of processes, isn't
Yes.
it, in terms of the Commons, which controls its own procedures. There's no legislation, no going to the Lords, and that's a sort of parallel track, but it's only for certain things that can be achieved, obviously, within the Commons. Then you've got the legislation, but then you've got the things that you can do without either. And I want to throw it out to the audience in just a moment, but let me just end on this one that we've been trying to think during today. And if I'm allowed, I didn't ask Hannah's permission for this, but I was going to mention it at the end, so let me mention it now, that the Institute for Government and Constitution Unit are currently working on a little report on the options for constitutional reform for the next government. And we're dividing it into what we're calling quick wins, which are the things that you could effectively do within the first 100 days. They don't need legislation. They may not need much consultation. There are plenty of things that you can do by seeking to change convention, by using prerogative powers, things that you can announce on the steps of Downing Street, announce new reviews and so on. You've got that stuff, and then you've got the stuff that needs legislation or wider consultation that you need to program in year 1, year 2, year 3. And then you've got the really big difficult stuff.
Yeah.
So how should a government or an aspirant government balance those things? And maybe also, what would your quick wins be?
Well, I think if you've got to make a decision about whether you're interested in any particularly big constitutional reform. If you're interested in, for example, electoral reform, then you can't go straight into it. If you want to do that, you'd have to set up a Jenkins Commission Part 2. You can announce that straight away, and that would be processed in that direction. But I wonder whether there'll be any appetite for that. Secondly, there's a whole range of commitments you could make straight away, like you will never send to the House of Lords somebody rejected by HOLAC. You could, for example, say you will require ministers to sign a contractually binding document saying that they've got to comply with the ACAPA proposals, instructions, and if they don't, they are liable to be in breach of a contract or an obligation entered into or an undertaking entered into by the state. Thirdly, you could say that you would invite the political parties straight away to reach an agreement on how they reduce the size of the House of Lords. All of those not requiring legislation, all of those, I will not send somebody without Holyoke's permission, ministers have got to enter into contractually binding undertakings in relation to ACAPA. You invite the political parties to agree reductions in the numbers. They can have permanent effects, because it's not just, well, the HOLAC one may not have a permanent effect, because you might have another Boris Johnson who'd come along and say, well, I'm now the Prime Minister, I'll have anybody.
But we've never had a convention of the Prime Minister committing to a balance among the number of peers made, or the number of peers made. So we haven't even got a convention to break. So trying to create one would be a start.
And the consequence of there not being such a convention is you now have this very skew-if political position in relation to the Lords, where the most populous minority in the Lords is the Conservative Party. The second most populous group is the crossbenchers, and the third most populous group is the Labour Party, then the Lib Dems. The Conservatives have appointed people who are much younger than my colleagues in the Labour group. So you see a lot of incredibly sprightly Tory peers who were appointed years ago and still look only 45, whereas our peers are all appointed at an enormous age and are now very, very old. So we're older, smaller, and so
I remember the mirror image of that happening in sort of 1997, 1998, and so on, Charlie. Sin isn't all on one side.
Just to take up what Meg is saying, there are those things that don't require legislation at all. There are then things that you can do by legislation, like, for example, you can stop the hereditary by-elections straight away. And would there be any opposition to that? If there was, who would? Maybe the Conservatives would oppose it, but you're assuming for these.
Lord Rees-Mogg.
Lord Rees-Mogg might oppose it, but you would assume on this basis that there would be a Labour majority of some sort. So you could do that. You could put HOLAC on a statutory basis at that particular point.
And several of these other bodies, as CSPL has proposed.
Yes, exactly. And then it's your third group, Mega, which there won't be an appetite for. But that comes much, much later.
So it sounds like, I'm going to bring David in and then go to the audience. Charlie's sort of saying, pick your fights. Choose your one or two big things that you want to do and plan carefully. Do some stuff quickly that you don't need legislation for, and then have some stuff in between. Do you agree with that? And
I agree with that in a political approach. I think would tick pretty much the same box as Charlie's done. I would add to that empowering the Prime Minister's ethics advisor to initiate his own investigations and not wait to be commissioned to do so. But I think I would also make some announcements that could not be implemented sort of overnight, but which would, I think, require then subsequent follow-up and implementation. One, in my view, should be a commitment to make the devolved settlement work. That message, I think it's important to send to Scotland, Wales and Northern Ireland.
Is a possible reiteration of the Sewell Convention?
Reiteration of Sewell. I would not put Sewell on a sort of make it binding in the way that the Scottish Government wishes us to. That would just end up with litigation there. I think
there's quite a lot of legislation already which gives effect to great chunks of the
There are recommendations from the Dunlop Review.
Yes, but
already in legislation.
There is the arrangement that we in government, like the deal I did with Carwyn and Mark Drakeford, to get the first EU withdrawal bill through the House of Lords when I came into the Cabinet Office in 2018. Which was to establish by statute a procedure under which ministers had to report in a given timescale to the devolved governments and parliaments about what they wanted to do, and if there was a disagreement, if there was a refusal of legislative consent motion, the reasons for that had to be reported back to Parliament in Westminster within a given time frame, and those reasons published, not just glossed by the Secretary of State. And we set up a process there to ensure that their views could be properly considered by Parliament in the UK, which then the Welsh Government accepted was sovereign and was entitled to make the final decision. So things you could do there, both parties are verbally committed to further devolution within England, to sub-regional level. Now, again, that is something that could be said on day one or day two, even if it took some further legislation.
And I see Bridget Fowler from the Hansard Society at the back, so some sort of statement about the proper dividing line between delegated and primary legislation might be nice, for example.
Very good. Could I just pick up one thing that David said a few moments ago? The idea of the backbench committee of the House of Commons fixing programming, which presumably carries with it the possibility of identifying some legislation that doesn't get programmed at all because it's too important, and it being, as you say, completely in the hands of the backbenchers, even though they may be a majority of government backbenchers, still they are not the government. That would represent a massive change in the way that our Parliament operated, because the essence of our Parliament, or the Commons, not the Lords, and it's the Commons that really matters, is that the government, not backbenchers, the government determine all diary issues, as it were, or programming issues. For backbenchers to start doing it would be a massive change.
It's a return to an older part of our tradition. Remember, Charlie, it was only in the 19th century when, in response to the Irish Party's tactics in Parliament, that the closure guillotine procedure was introduced for the first time. And the automatic programming of all legislation is something that the Blair government initiated out of frustration at people like Eric Forth, who were blocking legislation, talking it long in the Commons in the way that Dennis Skinner and Bob Cryer had done in the Major government. So I think that there is, I make no apology for the fact that I want to see Parliament strengthened at the expense of the executive. And I actually think now we've had several generations of MPs who have not come into a world of all-night sittings, there will be no appetite to go back to that, except in the most extreme circumstances. I would trust the Backbench Business Committee to come to a sensible decision.
There are some interesting proposals in the Constitution Unit report, Taking Back Control, which you can find on our website. I think you'll find things on the Hansard Society's website and on the Institute for Government's website. I promised to get to the audience, and time is ticking away. And of course, we started late, so we have less time than we originally planned. We have a really high-quality audience here in the room. Let's take maybe 3 questions at once, and there's a roving microphone so that the people online can hear. Who's got the microphone? Tom? We've got one here. And could you say, for the benefit of the online audience, as well as others in the room, who you are?
Thank you. Alex Horn, I'm a barrister and visiting professor at Durham University. Talking about sort of going into this type of reform, one thing that wasn't mentioned was the Brown government's Governance of Britain review, which may be because it was fairly forgettable, but it did identify quite a lot of problems that haven't been resolved, including, I think, things like the role of the Attorney General, the War Powers Convention, how Parliament deals with international agreements, all manner of other things. We've now sort of moved on to a sort of newly fashionable group of other things, but is there a danger that we sort of move on slightly too quickly and leave behind quite a lot of work that's already been done when we're looking at doing this?
Interesting. There's another Brown report on the books these days, of course, which I thought you were going to refer to. Philip.
Thank you, Philip Norton, Lord Norton of Louth, one of the sprightly peers that Charlie Falconer referred to.
One of the most admired peers, if I may say so.
Really to pursue a point with which I'm very much in agreement, but the problem arising from not having a minister who has designated responsibility and the problems that creates. Now, David touched upon the Constitution Committee and the Lords. It produced a recent report on the position of the role of the Lord Chancellor and the law officers, and what it raised was what David was touching on, perhaps taking away aspects of the being Secretary of State for Justice, prisons, going back to Home Office, something like that. So you had a Lord Chancellor who was more focused on constitutional issues and picking up on some of the points you were alluding to, somebody who's very senior, can represent it, protect the rule of law, defend the Constitution within Cabinet as well as beyond. But what I want to pick up on was not just having a minister designated, but known as that minister. Because at the moment, in response to the Constitution Committee report, which is recent, the government's response kept emphasising the Prime Minister has ultimate responsibility for the Constitution. Clay thought this was important because it said it several times. And that other responsibilities for the Constitution are spread among a range of ministers. I put down a question which got answered last week, what minister is responsible for the Constitution, because I was conscious no senior minister quite often has responsibility for the Constitution, qua Constitution. I got the response, it's now the Deputy Prime Minister who's responsible for the Constitution. I can find nowhere on the public record that identifies that fact. So the point I was going to make, it comes back to what was said about Charlie. You were Secretary of State for Constitutional Affairs. Now, it could be a Lord Chancellor as that equivalent or with that responsibility, but the importance of having somebody who is clearly designated and with the clout to make it impact to protect the Constitution. Because I agree with that point. It's not looking just at change, it's how you promote the Constitution, particularly in the context of the Union. Because at the moment we're very much in response mode, not making the case for I think things like that. You have a Secretary of State with that responsibility, with the clout, to ensure other ministers take it seriously, and it's not seen as a silo. Oh, they're responsible for the Constitution, we don't need to think about it. Somebody who can make sure it is throughout government. So I suppose my question is, don't you agree?
Handy manoeuvre. Hannah.
Thank you, Meg, and thanks for all your kind references to the Institute for Government's work. I'm director of the Institute for Government, and I'm going to ask a very predictable IFG question. So, in recent months and months particularly, but years and months, there's been increasing tension between the ministers and civil servants. Do you think there is anything? What would you propose in order to address that situation? There have been, in particular, questions around the issue of civil service impartiality, whether that remains an important tenet of the way our system works, or whether, in fact, it's no longer something that we ought to be striving to preserve, and that actually it has some negative effects. So I'm just interested in both of your thoughts on whether, I mean, the IFG has thoughts about passing legislation to put the civil service and the status of the civil service on a statutory footing, and clarifying the accountabilities and responsibilities of ministers and civil servants in a way which would make their roles clearer and have benefits, we think, for both sides. But even much more sort of something more declaratory, as you were talking about the value of that in respect of other changes, might be beneficial, but I'm interested in both of your views.
Terrific. David, would you like to start? And if we keep it fairly short, we'll hope to bring in one or two more
I mean, you're quite right. We should not forget about those ideas that have been mooted in the past, but then been allowed to lapse. I wouldn't necessarily agree with the whole of that Brown package. Actually, the War Powers Act idea we did look at in opposition and then in government. And William Hague, as Foreign Secretary, was initially very supportive of that idea. And then we looked at how that would work out in a crisis. And we just felt that you couldn't tie the hands of government to respond in that way. In practice, since Iraq in 2003, I think no Prime Minister would commit troops to action without getting, if not a vote in advance, a vote within a short time afterwards to approve it. So I think we've moved in practice closer to the American way of doing things on that. Philip, yes, is my answer, straight away. And I think problems arisen in part because Michael Gove took devolution with him, but left other bits of constitutional affairs behind at the Cabinet Office. I think Oliver has just tried to sort of claw all of that back. And that is one way, not the only way, but it's one important way in which that can be done. I think on Hannah's point, well, I'm slightly party pre here, having been on an advisory panel for the review that the IFG and Constitution Unit and Benefit Institute are doing. I loathe the idea of a more party political civil service. What that would mean in practice, nobody's going to appoint some great partisan to administer the operations of the benefit system or the prison service. And this is going to be policy wonks who are employed as policy advisors. So what that means, you get a change of government, all the key senior policy people vanish. You have to appoint new ones. Now, do they, as in the US, need to have parliamentary approval? Or do they need to appear before a select committee to be interrogated before they are appointed? Bonkers. I mean, in my 9 years in government, I would never dream of asking a career civil servant how they voted in the privacy of the ballot box. And civil servants, like every other walk of life, people vary in quality. But I have seen civil servants, and this is true certainly of all the senior ones, they have served both Labour and Conservative governments. Now they'll largely serve Labour coalition and Conservative governments. And I've always taken seriously the fact that the career commitment, partly my dad was a local government officer who did work for the GLC under both Horace Cutler and Ken Livingstone. So he'd seen both sides. And your duty, professional duty, and your professional pride is in doing the very best job you can for the success of the policies of the people whom the electorate have given you. And I think that is something of great value in our system. I would like to see a new Civil Service Act, because I do think we can't, after Johnson's approach, we can't rely on good chaps and conventions any longer. So I think we need to entrench the right to give frank and impartial advice, and perhaps to define the role of the head of the civil service as opposed to that of a cabinet secretary or a secretary of state.
Charlie.
Alex's point, yes, there's a tremendous tendency to have good ideas then disappear. I am not in favour of any change in the role of the law officers. I think it's good that there are political law officers, as long as they respect that they are in a different position from everybody else. Having a law officer able to speak to their colleagues and say you can't do that is incredibly important. So, and with the exception of Suella Braverman, law officers in recent times have completely respected that convention, and the current Attorney General is somebody who plainly respected. And I do not regard Suella Braverman's massive and repulsive failure to comply with the role of the office as an indication that you should change it. You're never going to be able to protect against the occasional sort of person who doesn't do the job. In relation to war powers, I do agree we shouldn't have an act. I do agree that politically it would be very difficult to use armed force now without the approval of the Commons. I do think it is important, though, that the government make clear that there is a process that they will almost invariably go through. And in particular, that means making the case to Parliament as to why they're doing it, apart from the law, and also being clear what the legal position is in relation to it. Because the legal position in relation to Iraq became so charged and caused a real problem about our legitimacy that I think, as a matter of course, they should set out what the legal position is, and the law officers giving the advice should be available to be effectively accountable to Parliament in relation to it. And that means more than saying we think there's a reasonable argument we can go to war. It's got to say this is what we think. In relation to Philip's point, I completely agree with the principle that there should be a Minister of the Constitution, and that man or woman should be somebody with status in government. It can't be somebody you've never heard of. I mean, I've heard of Oliver Dowden, the Deputy Prime Minister, but I mean, it's absolutely extraordinary that you had to wiggle his name out, and, and presumably Mr. Oliver Dowden didn't know he was responsible for the Constitution until somebody said, "Oh, that Lord Norton of Louth has asked a question. We better work out who's going to do it." It's really, really important, so that when things go wrong, Parliament can say, Oliver Dowden or David Lidington, how the hell did you allow us to get into this mess with the Scots, the Northern Irish, the judges, or whatever it is? I don't agree with you, but I don't think we should go into it now about taking away prisons and probation from the Lord Chancellor. I think the Lord Chancellor is responsible for the court service, including the criminal justice service. If you take prisons and probation away from him or her, you're bound to give it to the Home Office, and that means you're cutting away from the judges who are responsible for sending people to prison or giving people information, any knowledge of doing that. And my God, it would make the position a lot worse than it is at the current time. Ministers and civil servants, I am as committed and as upset at the idea of these ministers trying to blame civil servants for all their own failures, which is what's going on. I do think you need in some way to entrench their position, but I think ministers should be able, not on policy grounds, but on delivery grounds, to be able to say, I'm not sure that this is the right mix. There needs to be a process about how you do it. The Tom Scholar example is the absolute disastrous counter to that, because he was sacked as a political symbol, which is a terrible thing to do. But there was a conversation I heard from a very, very senior ex-minister who said, I was in the Home Office, my permanent secretary's time came to an end, they wanted to appoint another permanent secretary who he thought was very similar to the previous one, but what he wanted was somebody who's willing to reform the Home Office, and there was a big row about it, and eventually he got his way. I don't see any problem with that sort of involvement in relation to ministers, but you can only get to that point if civil servants are absolutely confident that their political views will not in any way, I don't mean their political views, but I mean the classic example is we do not want ministers to say, unless you're in favour of Brexit, we're not having you as the Cabinet Secretary. That's got to be absolutely verboten. But what has got to be okay is to say, look, I want somebody a bit more dynamic. But you only get to that if people are absolutely confident that the law will protect you. And there must be a price to pay for how they treated Tom Scholar. You might think the price they paid was the Prime Minister, the Chancellor Exchequer were booted out of office within 25 minutes. But that is not a reliable thing. Just one more point. The Constitution Committee, of which I am a member, and John over there and Rachel over there, the officials are writing a report at this very moment about the hiring and firing of permanent secretaries, and has there been a significant change in relation to that? Do ministers, the Prime Minister in particular, but other ministers as well, treat permanent secretaries and the Cabinet Secretary as if they're ministers who can be reshuffled? Because that's what you do not want to happen.
Thank you. Now, we're pushing up against our end time, but we started late, so I don't want to miss the opportunity, if it's okay with the two of you, to have one more round of questions. I don't want to try your patience too much, because I know you've got homes to go to, but I see Jill, other hands, one at the back.
Hi, Jill Rutter from Institute for Government in UK and Changing Europe. Are there any pieces of law where government has given itself massive powers that you think should be taken off the statute book to prevent future governments being able to use secondary legislation to bypass Parliament scrutiny?
One here.
Fiona Weir, Joseph Rowntree Reform Trust, building on exactly the same point, a partisan statement, but one of the ways in which you could readily and quickly progress in many areas would simply be to repeal much of what has gone through the statute books in the last few years. So what are the mechanics, and how do you go about getting a very fast repeal agenda organised?
And Alan.
Thank you. I have a couple of questions from the online audience.
Ooh.
So one is from Keith Raffin, former MP and MSP, who asks, as the shadow leader of the House, Thangham Debonair has confirmed during this conference that Labour is determined to reform the House of Lords in its first term. How realistic does Lord Falconer think this is? Isn't incremental reform, such as reducing the number of peers, more likely to succeed than radical reform to elect the second chamber? And a senior official in the Scottish Government asks, could David Lidington expand on his view that Sewell should not be given a firmer basis? Its importance over the first 19 years of devolution was to create an incentive for the UK and devolved governments to negotiate, co-produce legislation and agree. Since 2018, that lever has been lost to devolved governments, and the UK government has found it painless to override the views of the devolved parliaments 9 times and counting in Scotland.
Just those few little things in the last couple of minutes. Charlie, would you like to start?
Yes, first of all, I mean, massive powers. I mean, it's not massive powers recently given, but the lockdown powers were absolutely scandalous in their width. As public health allowed the government to do anything it wanted, literally anything it wanted. And what it was doing during that particular period, this is not about the substance of what they did, they would do things by edict, which didn't have to be approved by Parliament. By the time these edicts did have to be approved by Parliament, they got some new idea, and so they would have another edict, and Parliament was completely excluded from it. Now, as it happens, I supported the government in relation to lockdown, but that is not the way that in that sort of situation a parliamentary democracy should operate. They should have had to have explained and got approval in relation to it, and there should have been from time to time climactic votes.
And you had Steve Baker, Graham Brady, Mark Harper on your side on that.
Well, I did, and I think they were right, though I was not with them in relation to it. But what happens, and this is so key to our democracy, what happens if you've got to explain to get it through, and you've got to satisfy these people, the quality goes up dramatically. So that is a massive power example. And the related question, repeal, what have we got in the statute books to repeal? Well, it's the Public Health Act in 1985, which was the balloon of the peace in relation to it. Are there other things? There's lots and lots of other things. I mean, for example, the public order provisions that have now been gone through, the illegal immigration bill that's going through at the moment, the internal markets bill. There's so many that needs reform, but you can't just repeal. As those nut jobs in the Department of Business tried with the EU repeal provision, you just can't do that. You've got to have something to replace it with, rather than just handing it over to ministers. And then the man from the sky, reform of the Lords. If we have a majority of 150, when we get into power as Labour, you might be able to do it in the first term. If you've got a majority of 1 or in a minority government, it will be a lot more difficult when there are lots and lots of other things that may take time. So I think, Keith Raffin, the answer is that it will depend on the parliamentary majority.
David.
Running sort of quickly through these. I mean, Jill, first of all, I think that there are umpteen pieces of legislation from recent governments and from Labour's period in office before that, which contained extensive powers to make secondary legislation. And I think the big issue that we haven't had time to tease out tonight is scrutiny of secondary legislation. I think that there needs to be more effectively within government, until the Brexit process meant that government suddenly had to look at hundreds of SIs just to give effect to Brexit in a way that didn't cause chaos and regulatory lacunae. There was no such process, and I think there needs to be that in government, and there needs to be a better parliamentary process. The problem with that is I don't see that the Commons is going to provide that. That would be a natural role for a reformed upper chamber, but I don't think you could do that while the upper chamber remained on an unelected basis. So it might be part of a new reformed constitutional settlement with a reformed upper house, that you gave them delaying powers, or even a real veto power than the notional one, rather than the notional one that they have at the moment. That then acts as a discipline on government, because the power wouldn't have to be used much, but if it was there and it was believed to be credible, then governments would be more cautious about how they went about SIs. On a fast repeal. I mean, a government can bring forward a bill that has about 3 clauses and says, the Pipelines Under the Sea Act of 1878 is hereby repealed. This bill shall apply to the whole of the United Kingdom. Clause 3, this shall take effect at royal assent. And that's it. But it would still need to go through the whole parliamentary process in both houses, and I would not want to short-circuit that unless there were cross-party agreement. And it going through, of course, it would be open. It would be in order to move amendments in either house to do with any of the content of the bill that was being repealed, and say that except for clause X or schedule Y. So, I don't want to get to the position where governments have the power to railroad through fast-track repeals. I think that on Keith Raffan's point about Lord's reforms, I mean, I buy what Charlie said in the very opening remarks about a number of reforms that could be made as early wins. And I think that there'd be a lot of cross-party support for those. Yeah. In the context as post-election, I think that if whoever is Prime Minister after the next election then were willing to put the energy behind it, there would be a natural follow-through in the debate. Well, if you're doing this, right, compulsory retirement age and or term limits to help limit the size, so that would probably need legislation. Then you get on to, it would take a year or two, what sort of powers should the body have, and then if it's going to have these powers, how should it be selected or elected? But you'd need to think through that, you'd need to consult on that, and then you'd need legislation on it. So realistically, and have a new Parliament Act to define what the powers should be and how the reform, the second house sits apropos the Commons. That would take you into the latter part of a Parliament. We carries political risk because the government might then be picking up unpopularities.
Just to be clear, my answer to the Keith Raffan question was intended to be about a massive reform, not a reform along the lines of what you're talking about.
Some of the things even count as quick wins.
Exactly.
But I would, personally, I've always voted for a partially or wholly elected upper house, and that's the way I think things need to go in a modern democracy, and I would have a Parliament Act to regulate the powers of that chamber against the Commons, but that wouldn't be done in year 1. That would be a year 3 sort of effort, perhaps. It could even slip to a second term if the government achieved that. But I think the debate, if the government wanted to, the early wins could be used as the trigger for a more far-reaching debate about that parliamentary settlement. On the official from the Scottish Government's point, well, I thought that my old sparring partner Mike Russell put it very well when he was speaking about this, and said that Sewell is there to be followed, save in exceptional circumstances. And I think the overrides that were being complained about took place very much in the exceptional and extreme context of the Brexit debate that did arouse passions. But I think there has been a particular problem with Scotland in recent years because the Scottish Government, with the SNP government, has a single strategic objective, which is Scottish independence. And I don't think it's an exaggeration to say that there's a risk that it's an attraction for them to see everything else as a potential source of additions to the catalogue of grievance against the UK government, and therefore strengthening the case for independence. What I did find, though, when I used to sit down with Mike Russell and other Scottish ministers, even with the SNP government, you could find a way of accepting the profound differences that we had over constitutional affairs and work together. And I go back to where we got to on the whole wretched Brexit business, where there was something, I think 153 areas of policy that were being returned from Brussels to the UK where they intersected with devolved administration rights. And we got it down to 4 out of the 153 where we were unable to come to an agreement with Scotland, Wales and Northern Ireland on how this should be handled. A lot of them could be done by memorandum of understanding, non-legislative deals. Actually, what others, when you looked at the detail, we didn't need to worry about it. And we got to that handful of really difficult cases. So an awful lot could actually be done in a very unglamorous way. And actually, but as Charlie said, mainstreaming devolution across Whitehall, and therefore having a senior minister who is driving the need to be aware of that and to do it in practice, has to be an essential part of getting the devolution settlement right.
Thank you so much. Thank you everybody here for your patience, and yes, at the same time I'm sorry that we have to finish there, because I think we could have gone on for a lot longer. Let me just say a few administrative words here before we get to the very thanks. Just to remind everybody that this event has been being recorded, and it will be available shortly as a video and as a podcast. If you think it's been a good event, then do make sure that you share the link with your friends and encourage them to watch and listen. If you're not already signed up to hear about the Constitution Unit's upcoming events, then I would strongly encourage you to do so by going to our website and clicking on the Get Involved link and joining our mailing list. But I can give you advance notice now that our next event will be at lunchtime on the 19th of July, when the journalist Ian Dunt will be appearing at a seminar to talk about his new book, How Westminster Works and Why It Doesn't. And it's not just about Parliament, it's about the system as a whole. And we've got 3 excellent respondents on parties and elections, Parliament, and government and the civil service. Will be in discussion with Ian. So that's enough of that. Let me move to thanks. To thank these 2 fantastic speakers. This has been a wonderful, fascinating evening, and I think we could have gone on a lot longer, but we've benefited enormously from your wisdom. Thank you very much to the audience who are here and to your wonderful questions. Thank you to the audience online, and sorry that we couldn't get you all in. But I would also like to thank really all of the speakers who's taken part in our conference in the last 2 years, it feels like that. It's been enormously enriching. We've had some really fascinating discussions. Thank you also to all those who have chaired our panels, who fielded questions at our panels. And particularly maybe now is the moment to thank those by name who have helped behind the scenes, including Ed Rowe and Sophie Andrews-McCarroll, but also various others who've made all of this happen so smoothly. As I've given you advance notice earlier, the Institute for Government and Constitution Unit do hope to publish a report very soon on options for constitutional reform under the next government, and I think it's been very much enlightened by the discussions that we've been having over the last 2 days, and not least this evening. So thank you very much, everybody, and I hope to see you at another of our events very soon.
Thank you.